All right. Good evening. What's going on, everybody? How is everyone doing tonight? Hello, Mr. Nathan. And chat. Hello, Woody. What's going on? What's going on? TikTok, Nate. Hey, it's 5 o'clock right on the dot. I made it in time. Thank God. Thank you. It's been one of those type of days. I'm like exhausted. I was out with the kids all day, so now I get to come and talk to you guys for about an hour and show you guys what I found. So, to be honest with you, Johnny Depp, Amber Heard is really starting to get less and less exciting. But then every time I think I'm done with this story and we're looking at other things, I get dragged back in. Now, part part reason why I want to cover their response to Amber Heard's motion to throw everything out was just in light of fairness, right? We've heard their legal arguments on the other side. We all say they're trash, they're ridiculous, but now it's good to hear the other side, what they actually have to say, in all fairness. And second, it's like, my God, like this is really crazy. Every day somebody's suing someone else. It is insane. Yes, no, I watch that umbrella guy. I watch that umbrella guy. And he is good. He is good. He is good. And I watch actually everybody else. So it's been fascinating. Hello from Belgium. Was it Belgium? Yeah. Hey, how you doing? How you doing? Hello, hello, hello. So there are a couple of things that I see that's going on with this case now, as of now. So first, if you haven't been keeping up with it, let me add this to stream, see if it's ready. So we have one thing: New York Marine and General Insurance Company. They're suing Amber Heard. That's one piece of this. So let me show. Let me see where should I start. I'm thinking about where I should start with all this because it's a little bit more intricate than just the. It's like there's so many moving parts. I'm trying to wrap my mind around it. Nate, how you been? I've been all right. I've been all right. Thanks for asking. Thanks for asking. My voice is smoothing. All right, let me get back to the story. Okay, so after the trial is all over, Amber has been found liable for an intentional act. Now it's a little weird because with defamation, generally, if you're not a public figure, the mental state is only negligence. You just have to prove the person was negligent. But when you're a public figure, you have to prove the person acted with actual malice, or you have to prove the person intended to do it. Now, if you can prove the person intended to do it, that turns it into an intentional tort, right? That's something the person intended to do. And when that happens, the insurance companies generally don't have to cover you for intentional torts. So and it just makes sense because let's say if if I take out insurance on my phone and then I go and destroy my phone and then put an insurance claim in, the insurance company is not going to cover it. They're going, you did that just to get a new phone. People would be doing it all the time. That would kill the insurance companies. So here, if you get caught doing something willfully, as with Amber Heard, the insurance company is going to come down and say, we got a problem. So that's what all this is about today. Let me get to this. So first, we have Marine General Life Insurance Company. They're suing her. And this principle I was telling you is actually enshrined in law. This is California Insurance Code Section 533. And it says an insurer is not liable for a loss caused by the willful act of the insured. And that's exactly what I've explained to you before. If I intentionally break my phone and have insurance on it, the insurance company is not liable for that. They don't have to pay that. But he is not exonerated by negligence, essentially an accident, of the insured or of the insured agents or others. So California law says this is the way it rolls. And the reason why we're looking at California law is because Amber Heard's insurance policies are all from California. So California law is controlling here. So here in the lawsuit, and the lawsuit with the insurance company, New York Marine, they put here in the complaint, a jury's factual findings established that Heard's liability is caused by willful acts. She willfully lied, right? The jury sat down, and because Depp is a public figure, the question to them was, did Depp intentionally? Did Amber Heard intentionally lie? Right? She had to know it was false. She had to intentionally do it. That's what she was found liable for. So now the insurance company is saying, Well, that's just as bad as if she broke her own phone and then asked for us to cover it. That's essentially what's going on here. Um, Boop. And as you can see, they cite California code, insurance code 533. And this is they believe in this so strong that every one of their courses, just to put it really in a bow, they love this part of California law so much that they cited it as the only piece of law in every one of their causes of action. So check this out. And they have three causes of action. The first cause of action, California Insurance Code 533. They put it little twice. The next one, California Code 533, right? The next cause of action. They put in a title this time, California 533. So it's just so they made it known. This is she's been found willfully liable. And if that's it, it's done. She's done. Willfully liable. So we ain't got to cover no more of that because that means she intended to do that. She did that. They found that she did that willfully. Oh, I got the uncivil law hype. What do you mean I'm hype? I'm just relaxing here. Yeah, having a good time. All right. So I think at this point in time, it's simple. It's simple. And I think most states have this law. Now, why I put this up here? Now, what makes this interesting is that under this insurance policy, the ones that this was a $1 million insurance policy, and they help pay some of the legal fees. And here they actually explain how they the liability is $1 million. The occurrences liability $1 million per occurrence. And there's another lawsuit going on with between that company and another company called Travelers Insurance Company. Now, Travelers Insurance Company also insures Amber Heard. And let me pull this up so you guys can see it. I want to share this article from the LA Times. Mm, all right, here it is. So, move this, add this to stream. Here we go. All right, so Amber had two insurance companies. One was called Amber had two insurance companies. One was Travelers Insurance Company, and the other was this New York Marine. Now, Travelers said they paid up to $5 million for Amber's legal defense, and they let her pick her own attorneys. So with they and then they were suing Marine because they said, well, Marine's got to put some money up too, right? Because it shouldn't just be us. She got a $1 million policy with Marine. Marine should also put up too. So Marine is putting up. They want Marine to put up their mill, though whatever their policy, and they'll cover whatever they want to cover. So that's why they're suing New York Marine. But they've already paid. Now, the interesting part about this is that if you look at how much they claim they paid, $5 million, and then you look at New York Marine's $1 million, that comes out to $6 million. So let me go back here let me show you guys this. So Tug actually pulled it from the lawsuit. So this is that umbrella guy, as I like to call him, as everybody keeps saying. Nate, you keep saying the umbrella guy. So he reports right here from the lawsuit from Travelers suing Marine. In response to paragraph 8, Travelers admits it has incurred in excess of $5 million defending the insured, Ms. Heard, in the underlying action. They've already spent $5 million. So if you just add it all together, you get about $6 million, right? $1 million for this coverage where they're trying to get out of paying anything else. $5 million from the other insurance company. So it's about $6 million. But now, if the insurance company covered this are out $6 million for legal costs, then something just doesn't make sense because Elaine made it seem like Amber paid the $6 million out of pocket and it wasn't covered by insurance. Let me click this link so you guys can see what I'm talking about. I want you guys to listen to this testimony from Elaine. I mean, well, not testimony. I want you to listen to what Elaine is saying. Okay. So this is Elaine's closing. And in this closing, so let's just recap. We're trying to find out one or two things. How much was this? How much did it cost in legal fees for this case? How much did Amber? How much did it cost for Amber legal defense? And who paid for it? Right. That's what we want to know. Those are the two questions we want to ask, and Elaine's I think is going to answer them for us.
Got confused and gave the credit to Mr. Depp, not to Amber, for those. Then she made payments to both, and Elon Musk also made payments to both for $500,000 each, which she didn't count to her pledge, but they helped those organizations. At the end of the day, she's made $1 million in payments to them, but then she got sued here and hasn't been able to because she spent $6 million in attorney's fees. That is unrefuted. She still intends to pay those pledges.
So, just to be clear, Amber, her lawyer said the reason why she couldn't pay that money to those charities is because she had to pay $6 million in legal fees, right? $6 million in legal fees. So we know there were $6 million. We know there's probably about $6 million in legal fees, right? One insurance company said, "Hey, we already paid out $5 million, in excess of $5 million." So is that $6 million on top of that $5 million? And just because it's even a little more crazier, check out this one. So that was Elaine closing, telling us, I think pretty clearly, that she paid $6 million, not insurance. Here is the next one where she's even more confident in it. This one, she's even more confident. So this is her on the stand, and Elaine's going to ask her the question. First, you're going to hear her get caught up with Camille, but then Elaine's just going to straight up ask her the question. This is from Andrea's video on it, but it all comes together. But Andrea did a great video on it. I gotta put it in the description. So you guys check it out.
Able to to fulfill those.
So that's a no, right, Ms. Heard?
I made the pledge. I want to be very clear. I pledged the entirety. I haven't been able to fulfill those pledges because I've been sued.
And have you completely fulfilled your donations to the ACLU and the Children's Hospital?
I have not yet.
And why not?
Because Johnny sued me for $50 million in March of 2019. And I have spent over $6 million.
Objection, Your Honor. This is a motion in limine.
I have spent almost $6 million, right? I have spent almost $6 million. So is it the insurance that paid that money? Or did she pay the money? Or did they both pay the money? That it does not make any sense. So I don't know. Now, I do want to make it clear. I think something's obviously doesn't make sense with this thing. But I forgot to mention this last piece. Just because the insurance company paid the $5 million in fees, how do we know any of that money went to Elaine or in legal fees? Well, in the lawsuit between Travelers and New York Marine, they tell us who the hell they was paying. Here it is. Number 13. In or about June 2020, the insured replaced the Kaplan firm with Virginia-based licensed attorney Elaine Bredehoff of the law firm Charleston, Bredehoff, Cohen, Brown, and Nidelhoff, PC, Charleston Brennerhoff. So we know who they was paying. The insurance company, they paid the money to Elaine. Elaine's getting that money. So did she pay that $6 million for a lawsuit? Remember, that's the reason why she couldn't pay the $7 million to charity. She had to spend it on the lawsuit. Is that the reason why? Does that make sense? Now, there's a lot of smoke, but I don't know if there's fire. I don't know if you got enough. This has been troubling me because I thought we had. When I first heard it, I was like, "Oh, we have it. We got something here." But I don't know if we have enough. I don't know if we have enough. Look at Camille's reaction. Oh yeah, we're about to get to we're about to get to their response to all this crap. Depp's team's response. So now I do want to say we got to be careful of assumptions, right? This lawsuit could have costed $12 million. Insurance could have just covered $6 million, right? So we got to be fair to both sides, right? But I don't know. It's the way they are very loose with stuff. I'm thinking it may be. I'm thinking it may be. I'm thinking I don't know where to go with this. So I know some people are saying this is very suspect, but I don't know how much she paid overall for the case. So Pete said she paid zero. I don't believe she paid anything either. But is this enough to make that claim? I don't know. Well, that is the excitement that everybody's been talking about. But I don't think we have enough to make that claim. But I do think it's getting fishy. The fact that she, made those claims. Yes, I spent the $6 million. Now we know it's $6 million. There's a little smoke, but I don't know if it's fire. So let's talk about juror number 13. So sometimes in law, you read through all this crap and you're like, this is interesting. That's interesting. But then once in a while, you run up against something that makes you say, you know what? This is short and sweet and to the effing point. And I'm not saying the word because children may be watching at this particular time. But this response was short and sweet. And I'm not talking about their formalized full thing response. I'm just talking about their motion to strike the issue with the juror. And I'm going to read it to you because I think it hits all the points. It makes so much sense. And at the end of reading their one or two paragraphs about it, you're going to know why the whole juror issue was bull crap. So let me pull this up. All right. So let's go to page 1 of this. So this is the caption. So this is their supplement. This is their motion to strike the defendant's out of time supplemental memorandum. Now, really, I don't need to read this part to you. Essentially, they're deadlines, right? If you're at one point, the judge is going to say you have X amount of time to give me all your paperwork. Then essentially that time runs out, right? If you don't submit your paperwork before then you're not going to submit anything, right? Because the court doesn't have to wait for you to do whatever you want to do. So it just happens. So if you miss that deadline, then the court generally doesn't want to hear anything you have to say after that. And there were obviously exceptions to that rule. So here, that's essentially what happened. And that's what they're going to, that's what this motion is really to to point at. Now, and it could have been a lot quicker, right? This motion could just be, hey, listen, here's how much time you had. Here are the rules, blah, blah, blah. You violated the rules in this way and it should go. But they went the extra mile within this response. And in this response, they wanted to make sure it was clear why this whole juror issue was BS and throw a lot of shade at the other side. So, just to be clear, as a technical matter, even if we look at this is for being untimely, right? So this could be really a one paragraph motion, right? Here's when they submitted it. Here's what's the deadline. It's at X amount of days after the deadline. Here's the court order saying what the deadline is. Done, right? There's really not too much you really need to add into this, right? Because again, this is a plaintiff's motion to strike defendants out of time. You ran out of time. Supplemental memorandum in support of her post-trial motion. So, but sometimes it's good to take these opportunities to throw real shade at the other side's argument and let them know, let the court know, this is the BS that we got to deal with in a real succinct way. Because don't forget, you can't add too much fluff to this either. So this is really 3 pages. And what I like about this is going to really show you how when lawyers need to say stuff in a very short amount of time, they can do it, right? You get paid by the page, unfortunately, sometimes by law. But here, you're not getting paid for the page. So look how easy the arguments are. If you look, and these same arguments are in the other brief, but they're taking up pages and pages and pages of time. Here, we got maybe 1 or 2 paragraphs, and you got to get the point across. So let's see how they break it down. 3 pages. And then I'm going to ask you guys afterwards, what do you think about the juror issue? Do you think it's a nothing issue? Let me get the super chat. I'm sorry I waited so long. Isn't defamation always intentional by definition? No, you can have. There's different standards. So actual malice is a standard when you're talking about public figures. But then for people who are not public figures, it's negligence. So you could accidentally defame someone, right? Somebody may have the same. Maybe you see a name on something, and you believe that it's that person, but it happens to be someone else or something like that. There are ways that you can do it by accident, and then you could be found liable. But that's, again, public figures don't get that. That's only for people who are not public figures. That's why it's extremely hard for public figures to win defamation suits. All right, so let's start this out. It says pursuant to court's direction. So again, like I told you guys, this motion should be nothing but a page long, right? It's a nothing motion because it's really just saying you ran out of time. So here it is, right? Pursuant to the court's direction, Ms. Heard's deadline for submitting her post-trial motion fell on July 1st, 2022, right? 1 full month after the jury rendered its verdicts. Okay, that didn't really need to be there, but it's there. It is undisputed that Ms. Heard did not file her supplemental memorandum until the afternoon of July 8th, 2022, 1 week late. So, and only fewer than 3 days before plaintiff's Depp's deadline for submitting his opposition to defendant's post-trial motion, due on Monday, July 11th, but no later than 10 a.m. Now, essentially what they're saying is that you kind of snowball this, right? Not only did you give it to us, you give it late, but now you give it to us with only 3 days that we got to turn our stuff in. So we can't even sit on it and do it. So we've really been harmed, and this is the reason why. And obviously it's late, Judge, you set the rules forward. This is how we've been harmed. This is what happened. Now this could be ended here, right? This could be ended here. It's done, right? It's done. We shouldn't even be, there's really nothing else really to say, right? Boom, good. But they're going to go on. And again, this is what sometimes this is more litigation strategy than law. So it's like, this is also you're going to see speaking to the judge as a person. It's kind of like, I'm putting it in the legal way, but we all know what I'm really trying to say, right? So that's why I like the way they're approaching this particular supplemental memorandum. And I think it says everything in a very, very succinct way. So here it is. True to form, defendant neither notified the plaintiff of her forthcoming supplemental memorandum, nor sought leave of the court for filing it. 1 full week out of time. Because Ms. Heard filed late and without leave of the court, the court should grant plaintiff's motion to strike, right? That's all the law you need to know. This is how we've been harmed. Here it is, just we want it to be granted. Boom, done. Now, here we go to move on. Now, here's some other reasoning that we can also add to it to just help you understand why we think this is so bad. And again, we're going to try to figure out what this has to do with this motion being timely. So remember, this motion is about it being untimely. So now we're throwing in this section 2. So what does this section 2 say? It says Ms. Heard had access to the purported new facts a month ago. So I think they're trying to put it in here saying, well, we've had these problems with things that are timely before. And here's another issue. In her supplemental memorandum, Ms. Heard does not, because she cannot, make any proffer as to why she could not have discovered these new facts until now. This is because the clerk's office provided the pre-panel jury list to the parties back on April 6, 2022, more than 2 months ago, and 5 days before the jury was impaneled. Now, remember when we were talked about this in that earlier episode of this, when we saw that Virginia law said you got to have the name, occupation, address, and birthday of the juror 3 days before the juror was impaneled. They're saying you got it, and she's saying they got it in 5. But we go on. In a rare moment of candor, Ms. Heard admits that she was aware of the purported discrepancy in juror's 15th birth year from the very start of trial, because juror 15, and they quote Elaine, because juror 15 was clearly born later than 1945. Motion at page 40. Ms. Heard therefore concedes she had more than enough time before the trial started and during the 6-week trial when at least 2 alternatives were available to investigate and discovered these alleged new facts. Clearly, Ms. Heard waived any right to allege new facts. She chose not to investigate for so long, much less to demand the extraordinary remedy of a mistrial. And that, people, was 1 paragraph long. Cut right to the point. Chop, chop, chop. Throw your bombs. You read it, right? Boom. Boom. And this, they did it on the other one. It took them like 2 pages to do this. Here. Right there. Boom, 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 boom. I don't even have to read the stuff from the other stuff, right? You know exactly, right? It's all game over. Game over. You did admit you knew. You said it was all obvious. No one would respect that guy for a 77-year-old man. No one. Not even us. What does that have to do with the motion to strike? Because it's untimely. That has nothing to do with this motion. That's just the slaughter. We can slaughter them in one. Let's just take it. Let's just take a shot. Boom. Boom. Now, I'm telling you, people, I think it's only, what did it take? It's a paragraph. They destroyed that whole argument in a paragraph. And usually lawyers are very wordy. And then they end it. Ms. Heard cites no unfair prejudice. Even if Ms. Heard had filed her supplemental memorandum in a timely manner, which she did not, just to make sure you understand that. And even had she not waived her right to raise these alleged issues by sitting on the information for more than 2 months, which she did, The court shall the court should still grant plaintiff's motion to strike defendant's supplemental memorandum because Ms. Heard failed to cite, and I put cite any unfair prejudice. Even assuming arguendo that Ms. Heard's latest thesis that the son served instead of his father, there would be no prejudice, as Juror 15 was qualified to serve as a juror because he did live in the area and was above age, so he was qualified. Fairfax County, and was vetted by the court, the parties, counsel, just as all of the other jurors were. Boom. Boom. Now, I wish all motions were written so succinctly in a way that it's that you don't got to worry about it. It's done. But this is what you do is when you tell someone, listen, we got 2 paragraphs. Blow it away. Right? We got 2 paragraphs for this. Let's just end this in 2 paragraphs. And this is what you do. This is what they came up with. Right? So after reading that, there was no real reason to there's no real reason to read the other full motion. Oh yeah, I forgot the footnote. I forgot the shade on the footnote. I am so sorry, people. But yeah, somebody just reminded me. Nate, read the footnote. It is snarky. Let me pull this down. Defendant seems to have abandoned her prior baseless assertion, made both by Ms. Heard and her counsel on national television, that the jurors violated their oaths by watching social media during the trial, which in turn influenced their verdicts. Disgraceful that Ms. Heard made such scandalous allegations, and disappointing that no apology and recantation has followed. Now, that's the reason why you throw that in there is because they filed their motion. And their motion, they were going around TV saying that the jurors did all they know they was violating their oath. And now you've submitted the motion. And that's not in it. Apologies. This, I'm telling you, somebody, it's like, you know what they said, Joe, I'll give you $25,000 if you could take this part of the motion, these 4 pages, and give me 2 paragraphs, 2 of the best paragraphs of your life, and I'll even give you a footnote. And this is what they came up with. And this is what they came. This is why Johnny's paying them so much. Yeah, I think the juror thing is dead. I think based on this, I think the juror thing is dead. Oh man, let me get the super chat that came in. Oof. Makes sense they would add substance because then she can't claim they win on a technicality. Agreed. But I don't know. I just love to see when, okay, we're gonna use what we have, right? We don't have a lot of time. We want to throw a lot of shade and we got a lot of ammunition. But the problem is that we can't do it in 4 or 5 pages, right? This has got to be done quick, right? This is a motion to strike based on it being out of time. How the hell am I going to get all that up in there? How are we going to get all that up in there where the judge is saying this is all irrelevant stuff you're throwing out, right? You got to throw, how you want to throw it aside there? But you got things. You got maybe 2 paragraphs because that's the only thing is you got a footnote and you got some shade. And that's what they did. They said, we're going to make sure we condense as much as possible and seek and destroy. And that's exactly what they did. She even threw out the whole thing about them saying the jurors were corrupt. Boom. Hopes the judge reads the footnote. So, with that said, what do you guys think? So that's the happenings with the Amber Heard saga. as it stands today. So seemingly, it seems like the insurance company is not going to have to pay anything else from this, because if everything is under California law says, you know, it did, and that's it. Oh, that umbrella guy got swatted. Uh, they going dirty. Yeah, that's been happening to a lot of people lately. Uh, oh, they said, hey Nate, I DM'd you with a document from an insurance case. Travelers spent over $8 million on the defense from all the filings. It looks like they are covering all the legal fees. Ooh, so if that's true, if they're covering all legal fees, then yeah, that's crazy. That's crazy. Well, let me know what you guys think. Let me know how you guys feel about this. Um, let me see. I got some other stories I'm going to be covering later on this week. I'm just going to try to do the James Webb Space Telescope tomorrow, but mm, I don't know if that's going to be able to happen because my daughter got a last minute doctor's appointment, so we might be doing that. So I'm gonna have to push that back. But tomorrow's supposed to change the world, change science. So they spent $10 billion and put it up in space. I want to see what comes out of it. So hopefully it'll be nice. Sorry you didn't get the notification. Yeah, they tried to swat to. Uh, well, hey, this is unfortunately when you're out here just covering these stories, sometimes it gets crazy. So, listen, I want to thank everybody for being here. Thanks again for watching this. My name is Nate the Lawyer. Hopefully, you learned something interesting today, and hopefully, I'll be able to see you guys later in the day tomorrow, and we may look at some. We'll be talking about the deepest images from the universe and whether there is possibly extraterrestrial life on other planets. Who knows? I feel like this is a case. This case has become WWE. No doubt about it. No doubt about it. And with that, I'll see you guys a little later.